Okay, Ms. Price, I see a picture of you, but not you. There we go. Okay.
I had it on earlier and it must have clicked off. My
Yeah,
apologies.
put your screen down just a little more. There we go. Okay. All right. Ms. Price, are you ready to proceed?
I am.
Are you going to reserve time for rebuttal?
Yes, sir. I would like to do that.
How much time would you like?
5 minutes.
Okay, 5 it is. Please proceed.
Good morning. May it please the court, honorable judges, opposing counsel. My name is Kelly Garrity Price. I am an attorney with the law firm of Dentons, Cohen and Grigsby, and I represent the appellants in this case. We are here today on an appeal challenging a final judgment entered by the lower court following hearings on a motion to strike what the appellants believe was a timely motion for trial de novo following the referral of the underlying case to non-binding arbitration by the trial court. We are here today seeking intervention by the appellate court to correct the premature final judgment entered by the trial court after entry of orders striking the motion for trial de novo filed by the appellants within the 20-day window provided for in the statutes and in the rule that governs the procedures and policies for non-binding arbitration.
Ms. Price, we know that this case has the unique feature of a stipulated agreement for a period shorter than the 20 days called for by the rule. And we know that that period was 14 days. And we know that the request for the trial de novo came at day 18 or 4 days after the agreement. And we know that you have argued that that agreement should not apply for a whole lot of reasons. But the concern here is that there was this agreement. It was requested by your client, and the request for the trial de novo did not fall within the confines of that agreement. So I know you've, in particular, have taken the position that that there was no agreement because it didn't comply with the requirements of such an agreement. You want to talk to that point?
Absolutely, Judge. We have taken that position in our briefs, and in fact took that position on a motion for rehearing with the lower court as well. As we all know, there is a rule of judicial administration that requires stipulations to be in writing and subscribed by the parties that are to be bound by that. We included in our briefs case law that construe what the term subscribed means, and that means to be signed. And
but you had an exchange of emails, right?
We had an exchange for emails weeks after the verbal stipulation was entered into. There are no contemporaneous exchange of emails regarding the verbal stipulation that was reached by the parties in March of that year.
But there was a letter also, right?
I'm sorry, Judge?
There was a letter referencing it also, was there not?
There was a cover letter sent with an amended case management plan seeking continuation of the previously set trial on the court's July trial docket. That letter was March 26, 2020, and it was sent by Scott Lilly, who represented the appellee in the lower court proceedings. That letter was sent in final form, not including revisions that I had requested be made to that letter in a redlined email sent to Mr. Lilly before the letter went out. Critically important in the redline changes that I had asked for, but were not included in the letter that Mr. Lilly sent alone to the judge on the case management conference, was the reason the parties had entered into a verbal stipulation in March of 2020 regarding the shortened time period. The reason for that was the court was setting our case, or actually we were set on a July trial or June trial docket. We had a pre-trial conference set by the court for May 4, 2020. In prior hearings with the parties, the judge had made it clear at the lower court level that she wanted to know by that May 4th, 2020 date, whether any of the parties were going to be seeking trial de novo following the conclusion of non-binding arbitration. What happened here was in the very, very beginning of COVID and things shutting down and communities starting to adjust to having to operate remotely. Literally the evening before our non-binding arbitration hearing with the arbitrator on March 12 of 2020, the appellee is the party, along with her brothers, who requested verbally of the arbitrator in a phone call with counsel that we continue the non-binding arbitration. As the record reflects, Judge, it had already been continued once by the trial court. So this was going to bring us perilously close to the May 4th date for the pretrial conference. What I suggested was that if the arbitrator were going to continue a second time at the request of the appellee and her brothers, that we agree to shorten the time period for motions for trial de novo following completion of the hearings in March, so that we could comply with what the lower court had asked for, that the parties make known whether they were seeking trial de novo by May 4. That was verbal. Everyone agreed. It wasn't an idea of mine. It didn't come out of whole cloth. There was reasoning behind it. And the parties and the arbitrator, when he agreed to continue, agreed that that would be the way to proceed in keeping with what the trial court had asked the parties to do. That was the stipulation. The series of emails that occurred were weeks later, toward the end of March, when the parties were submitting an amended case management plan in order to the court about continuing the trial and other pre-trial deadlines associated with COVID. And in my revisions to the March 26th letter to be sent to the lower court, I had a sentence that is critical. And that sentence says, two sentences, at the request of some parties due to concerns surrounding the COVID-19 virus, the arbitration hearing date was postponed by the arbitrator from March 13, 2020 to April 6, 2020. And we anticipate completing non-binding arbitration by April 8. The parties have agreed to shorten the time to seek a trial de novo so that we may still be ready for the pretrial conference set in this matter for May 4, 2020. That and a following sentence identifying that it was within the trial court's discretion as to whether any of those deadlines should be extended within the trial court's discretion. Without my knowledge, without my consent, Mr. Lilly excluded those sentences and other suggested changes by me and unilaterally sent a revised letter to the court on March 26, 2020 that only said the parties have agreed to shorten the time frame to 14 days. Without
You got a copy of that letter, did you not?
I got a copy of the letter at the day it was sent by email transmission after it had been provided to the court.
Did you raise objections at that time to the letter?
I didn't raise objections at that time to the letter because whether or not it was going to become an issue depended on whether or not the court continued any of our deadlines, including the trial setting and the pretrial conference.
And that's my concern, Ms. Price, is that just to follow up with that, when that letter was submitted to the court, didn't you immediately say, no, that's not our understanding, or raise any issue, at least to protect, your client? Has anything like that, did you do anything like that at that time?
I had conversations with counsel, Judge, but in terms of writing to the judge who dislikes and discourages letter writing, that the letter as presented by Mr. Lilly was not correct. I did not do that. And
okay,
in fact,
and it's not, and if I may, and when you mention about trial judges discourage letters, but trial judges never discourage somebody raising an objection if somebody prepares a document for the court to consider that is not reflected accurately. And so I guess my question is, if an objection was not made at the time, is it really preserved for purposes of our review?
it is, and here is why I think it is, Judge. It is preserved because after this letter was sent, the judge did grant the amended case management plan. She did continue the trial. She changed the pretrial conference. At that point, based on my understanding of the stipulation, which is as I read the sentences from the letter that were taken out and not sent to the trial court. I had every reason to believe that the verbal stipulation, which was only entered into to comply with the trial court's request that by May 4, she know whether or not the parties were going to be seeking trial de novo, no longer applied. So the case law that we have cited in our briefs make it clear that in order for a court to construe a stipulation, the court has to understand the intent behind it. We let the court know the intent behind the stipulation when we had the hearing on the motion to strike the trial de novo request filed by my clients. I could not have anticipated on March 26, 2020, that opposing counsel did not have the same understanding of the verbal stipulation that I had. We all knew the reasons why it had been entered into. The reasons made perfect sense. It wasn't until the events transpired later with the motion to strike in the evidentiary hearing that I became aware that their understanding was different from mine. And we did not have a meeting of the minds about the terms of the stipulation and how it would apply if or when it would apply if the court continued our trial and continued the pre-trial conference date. So I had no way of knowing there was a need to do it at that point. We preserved it in our hearing on the objection to strike, as well as a motion for rehearing that we filed with the trial court in the proceedings below, setting forth again the reasoning for the stipulation and the rule of judicial administration, which candidly exists to protect parties from just this kind of situation and just these kinds of gotcha tactics.
Ms. Price, you keep, and throughout the proceedings below, you kept referring to these gotcha tactics. And it seems to me that the other side could make just as strong an argument that you all had an agreement. And now you're trying to say that use this gotcha tactic of, oh, well, guess what? I didn't sign it. It wasn't really a writing. So I think casting aspersions like that, is better avoided because it could be, it could go both ways. And it's all, I don't think it's actually relevant to the issue that we really need to decide. Even with your red line edits, I disagree that it was really clear what the court, how that should have been interpreted were those conditions not to come to pass. You would have put your reasons in the letter. We're seeking a continuance because of COVID and because we don't want to bump up against the pretrial. But there wasn't that follow-up, if a continuance is granted, therefore we will not need the extension. So or we will not need to shorten the time period. So I sort of feel like even with your reasoning, had it been included in the letter, that second part of the equation, well, what is the understanding if the pretrial and trial are not continued? That was still, that wouldn't have taken care of the problem.
And I hear what you're saying, Judge, but I think the sentence as I had phrased it for the letter to go to Judge Creer, and as we explained at the hearing we had on the objection, the entire agreement to shorten time was so that the parties could still be ready for the pretrial conference on May 4 and having made their decisions by that time period. That was the whole reason and basis for the stipulation. Taking that out just tells the court, we agreed to 14 days no matter what and for no reason. And it's interesting that in response to the briefing by the appellants in this case, the appellees they deny that the reason was tied to the pretrial conference, yet they don't give any other explanation for why this stipulation will be entered into at the beginning of COVID with all the things going on in this case. And that reasoning as set forth by the appellants is borne out in the record evidence and is borne out in the testimony that was taken at the hearing on the motion to strike the trial de novo request by my clients. Without the understanding of the basis and the intent of the parties when entering into the stipulation, the trial court couldn't construe it. So this is not a situation where my clients invited the error. We didn't ask the trial court to enforce this stipulation after the case was continued and the pretrial conference was moved. We didn't ask for the 14 days to apply after that. That was all done by appellees. And when the appellees did not include my suggested revisions to this letter and unilaterally sent their own form of letter, that is the party that invited the court's error, not the appellants. We have consistently taken the same position that there was a very narrow defined reason and need for this stipulation. And once the court continued the proceedings, there was no longer a need for it. And that would have been clear if my language in the cover letter had been sent. But it's an important distinction that these email communications between counsel in March of 2020 do not contain sufficient terms to allow the appellee to prevail here. It was
Ms.
email.
Price,
Ms. Price,
and
just
Ms.
so you know,
Price-
you're at 15
Oh.
minutes and it's your time. You can use it however you want. I just wanted to let you know. Okay.
Thank you,
No.
Judge. I appreciate that. I do want to reserve. And the last part I was going to say about that is the email exchanges were weeks after the verbal stipulation was entered into. This was a verbal stipulation with no contemporaneous writings acknowledging all of the terms of the stipulation by my client. And I'll reserve the remainder of my time. Thank you.
You've got 4.5 minutes when we return. Okay.
Thank you, sir.
Mr. Park?
Okay, please the court. I'm here obviously on behalf of the appellees. I kind of want to just kind of unpack some of what Ms. Price has said because some of it's extremely interesting. I think all three of you have picked up on some of the potential pitfalls for the argument that she is propounding this morning. Going first to this red line letter, one of the things that she is hanging her proverbial hat on is this red line letter that she sent back to Mr. Lilly, and then she's suggesting that the court should have relied upon language in that letter in construing the stipulation. Now, first of all, there's a big issue of fact here, which was resolved by the trial court after a hearing, an evidentiary hearing with testimony taken and differing points of view and differing factual assertions made by all the lawyers who were part and parcel to this stipulation. So it's a disputed issue of fact. And if it's a disputed issue of fact, then that's something that is an abuse of discretion standard. I think even the appellant has said that this is a mixed standard of review, that you have some issues of fact, some issues of law, which are de novo. But we have cited in our brief testimony from Mr. Gionis, Mr. Diodaro, and others who have testified as to the import behind the stipulation, what it actually meant and why. And so when Ms. Price is discussing the verbal stipulation or the exchange that took place on the telephone or on the conference between all the lawyers, there are disputed issues of fact as to what was said, why it was said, and what was done.
Well, one of the bigger issues that trouble me, Mr. Park, is whether there really is a stipulation. Has this been reduced to writing and signed by all the parties? And apparently not. And you've argued as to why it should be considered to be in compliance with the rule of judicial administration. So you might want to help me with that issue because it clearly wasn't reduced to a writing that everybody signed off on.
It was not signed off on by everyone from the standpoint of each party put a signature on it. But I think you were discussing with Ms. Price earlier, the fact, look, there is no dispute that there was a stipulation. Even in their brief, even in all the pleadings and filings and motions and everything, they've agreed there was a stipulation.
No, she hasn't agreed with that. She's made it really clear that she doesn't think that whatever it was, the agreement was, it was not reduced to writing and signed by all the parties as required by the rule of judicial administration. So she's taken that position very clearly.
The defects she's alleging is that it wasn't reduced to writing, ergo it's not enforceable. She's never said there wasn't a stipulation. In fact, she said that in her brief that there was a stipulation, it was an oral stipulation.
All right, so for the sake of argument, if you have an unenforceable stipulation, it doesn't get you very far. So tell me why this is enforceable.
Because it was a stipulation made between the parties. It was something they all agreed to. It was reduced to writing from the standpoint of put in emails. And I think I quoted one of this court or cited one of this court's cases where you were discussing. In that case, I think it wasn't enforceable because there wasn't a meeting of the minds. There wasn't all the essential terms of stipulation, but the inference was if it was an email exchange back and forth, that would be sufficient to constitute a writing.
Well, the critical thing here is that Ms. Price has made the argument that whatever agreement there may have been, it was only relative to a looming pretrial date. And once that pretrial date was moved, there was no longer a purpose for the whatever agreement there was. And therefore now to seek to apply it down the road when there's no looming pretrial that would make this odd number of 14 all of a sudden relevant. I mean, it's a pretty persuasive argument, you know, well, it is. I mean, why 14? Well, 14 happened to match up to that looming pretrial date. When that was gone, 14 has no relevance to anything.
Right, but the problem is what was sent to the judge was not the red line letter. It was the letter sent by Mr. Lilly, which supposedly was the negotiated agreement between all the parties, which was sent to the judge. And now Ms. Price is coming back, you know, months later and taking the position, well, hold on a second, I never agreed to that. But as you very appropriately pointed out, wait a second, you never objected to it. When that letter went in, did you get a copy of it? And she said, yeah, I got a copy that day by email. And then you appropriately asked, well, did you object to it? Did you say that wasn't the agreement we made? That wasn't the stipulation? And she said no. And in fact, she even said in the transcript, the trial court asked that very question. And in her testimony, Ms. Price's testimony during that hearing, she said in response to whether or not she had submitted anything after Mr. Lilly submitted that letter, she said, quote, I did not submit anything in writing. That's on transcript page 15 of the transcript of that hearing. And you know, let's not forget something, that whether or not you agree to about the 14 days or 20 days or whatever else, the appellants had sufficient time to file a motion for trial de novo. If there was any question.
Mr. Park, let me interrupt you, and I know you mentioned that in your brief. Let's go back. Whenever we're dealing with a disputed issue, whether one person says one thing, another person says another thing, and you've already indicated that there was a full evidentiary hearing on this precise matter. We have it right here. And so my question to you, we get to review any factual determination concluded by the trial court. If there is substantial competent evidence, we review it as an abuse of discretion. So right now, the court, as I hear your argument, made a factual determination based on what was presented and came to the conclusion, again, based on the testimony presented, that there was such an agreement and then enforced that agreement. So I guess my question to you, our review right now, what are we're supposed to do? Ms. Price is asking us to do away with that factual determination, or are supposed to review and saying whenever you're dealing with a stipulation, dealing with someone's legal rights, that we should have an additional, a heightened review so we can make sure that that the parties, you know, get a fair shake in this matter?
Well, I think to answer your question, I've got basically two responses. Number one, I'm not quite sure what she's asking other than she doesn't want her client bound by the stipulation or the terms thereof. I think that this is a factual determination, as I think fairly well demonstrated by the fact there was an evidentiary hearing on her motion, in that the court took testimony from all the lawyers involved on these very critical issues and made a finding based upon disputed testimony. And if you go back to
well, the problem is it's not disputed that there wasn't a writing and it wasn't signed by all the parties. Nobody disputes that.
Well,
so if the court made a factual finding that the rule of the judicial administration that applies to stipulations miraculously doesn't apply to this case, it's beyond me. And the court didn't really address why it didn't apply. It just made this finding there was a stipulation disregarding the rule. That's pretty much an abuse of discretion.
Well, I don't think that's what the trial court did. I think the trial court found that there was a writing. I think the trial court, and that was what was, that was.
And where were the
dispute.
signatures on this writing?
There were no signatures. from
Okay,
all
but the rule says
parties.
there has to be.
There's signature. I mean, if you take the two writings together, okay, so if you take the red line copy, the email sent by Ms. Price in her signature, and you take the letter sent by Mr. Lilly, those together constitute a writing. It was a stipulation that both parties agreed they entered into. They dispute now the term, not even the terms of the stipulation, they really dispute. They dispute the reason behind it. So that's another critical issue here is we're not really disputing whether or not the parties agreed to shorten the deadline to 14 days. What we're now disputing is what the reason was behind that, right? And so that's an issue of fact. What's the reason why? And what I was going to try to get to for Judge Kazam asked me the question was, I think one of the key issues that Judge Kazam brought up was, really a due process consideration, which is, hey, is this something that she's asking us to take a look at because they didn't have their fair shake or their fair day in court? But I would remind the court that this wasn't a situation where it barred them from doing anything. It simply reduced a 20-day time limit to 14 days. If there was any dispute whatsoever as to whether or not this trial for motion for trial de novo should have been filed, they easily could have filed it within the 14-day time limit and not had any issue whatsoever. And, to come back to the point of this letter, Ms. Price was fully aware that language, that quote, critical language that she keeps saying was so critical, was not included in that letter, yet she didn't object to it. She didn't inform the court, hold on, wait a second, that's not what we agreed to. The letter went in, that's what the court believed the agreement was, that's what the agreement was. And if there was any dispute about it, or if the reason behind that had gone away, then she very easily could have brought that to the attention of anybody and everybody, which she did not. And in fact, that's the testimony that Mr. Gionis and Mr. Dodano testified to in that hearing is like, no, this was not tied to anything specific. The reason why it was in the letter the way it was because we agreed to 14 days, period, end of sentence. And that's the factual determination the court made as to whether or not the reason behind it should have any impact whatsoever on the actual terms of the stipulation, which was a reduction. And once again, if there was any dispute, as a very good lawyer, you should say, okay, well, I'm going to err on the side of caution here and file within the 14 days. They had 2 weeks to file this. And I also want to point out that, going back to the gotcha language, if you look at what they're really asking for, the arbitrator basically split the issue. There's a homestead issue, which was resolved in my client's favor. There was the issue of the appropriate will, which was resolved in their favor. And so really, both sides kind of came out with something that they wanted. And so there was a situation here where if they didn't like that, they could have easily filed within the 14 days for a trial de novo, and they elected not to and waited to the 18th day. But now they're seeking to have the arbitrator's ruling against my client enforced, but they want to have another bite at the apple on just their component. So this really is a gotcha situation where you're saying, okay, I made a stipulation for 14 days. The other side's relying on it to their detriment by not filing a motion for trial de novo themselves within the 14-day time limit because they're okay with kind of the arbitrator doing a little bit for both sides. Oh, by the way, after the 14 days has come and gone, we're going to file a motion for trial de novo so that we can hear our side once again, but we're going to say that you're a stop from bringing up your side again. That's really the gotcha stuff that's going on here is they want to have their cake and eat it too. And so getting back to the whole concept of invited error, I think it is invited error where you can basically say to a court through acquiescence or even through submitting a joint letter to the court saying, hey, we're agreeing to this procedure. This is a procedural aspect of this case. And then, months later, come back and say, well, I don't like the result. Therefore, I'm not going to be bound by the procedure I agreed to be bound by. And that's kind of where we are. It's not fair. It's not equitable. And frankly, I think the court was well reasoned to do what it did, which was to take evidentiary testimony and to reason that based upon the totality of the circumstances, that there was a stipulation, it was valid, it was enforceable, it was reduced to writing, and all parties knew of it, and could have dealt with it. All parties had their day in court. And in fact, this is still going to move forward. This case isn't over. It's just this aspect of the homestead issue that they don't like, that they want to have another bite at. So hopefully that answered your question. And unless there are any other questions,
Okay.
all right.
Thank Mr. Park, you're done then. Okay, is that
Yes,
right?
sir. Thank you very much.
Okay, thank you, sir. Ms. Price, you have 4.5 minutes.
Thank you, sir. So I want to pick up where Mr. Park left off in terms of, and I know that the judges don't want to hang their hats on this issue of gotcha tactics, but there was nothing precluding the appellee from filing on the 14th day if that's what she thought the stipulation was.
Well, what's troublesome is what Mr. Park has said is that you waited after the 14 days to file for your trial de novo, arguing that there was no stipulation and seeking only for a trial de novo on your issues, and at the same time preventing them from getting a trial de novo on their issues because they didn't ask for it within 14 days. That's what he said, and that's troubling. So you want to address that?
I certainly do. And in fact, there was nothing precluding the appellee from filing on the 14th day if that's what she wanted to do. And
Well, if she filed on the 18th day, was that going to be a problem in your mind?
No, and as a matter of fact, I think that's probably what should have happened, Judge. So instead of, once we filed within the 20 days provided for under the rule in the statute, once the appellants filed for a trial de novo request, what I think should have happened is the appellee should have then filed a trial de novo request on the will contest issue, not this motion to strike and conditional request to assert trial de novo later if indeed they've succeeded in getting my timely motion for trial de novo stricken. The statute and the rule don't allow for this conditional got one leg in, one leg out argument, which is what they did. They could have within those 20 days filed for a motion for trial de novo on the will contest. And in fact, Judge, as we pointed out in our briefing, they were giving every indication that they intended to fight the will contest. You saw the history of the filings and the ongoing work in the case even after the 14 days and after the May 29th deadline in terms of motions for summary judgment and discovery directed to the will contest. They were giving every indication that they did intend to challenge that. And as we pointed out in our briefs, the appellants told the appellee and her brothers when we were in mediation that we were going to be filing a trial de novo. So all of the parties were acting like we were going forward to trial.
So is that the basis on which you've argued that DaCosta versus Naples Hospital should control this?
Yes, sir.
Aren't these facts different though?
They are different, Judge, but I think you get to the same place for the same reasons. And let's not forget that denying a party the right to a trial de novo on an issue based on the rule in the statute for non-binding arbitration can be construed as depriving the constitutional right to trial. That's what happened here because we filed within the 20 days. The reason for the verbal stipulation on the 14 days no longer existed. And the appellants had no way to know within the 14-day period that the appellee and her lawyers didn't see it the same way. They didn't reach out to tell me that they didn't see it the same way until after the 14 days had expired. So that is the reason we think that the case law applies to this situation. We have also argued that we can avoid, if the court were to find an enforceable stipulation exists under the rules of judicial administration in the case law, we've argued it can be avoided. In the case law that we cited on the avoidance, both situations apply here in terms of avoidance of a stipulation should the court find that an actual stipulation existed. And we cited the case law on that, and you can avoid it if there is some error in reaching the agreement or on the harm resulting if the agreement were enforced. Both of those situations are present here. The harm is that my clients are deprived of their right to trial on the homestead issues. With
You're down
regard
to 15 seconds, just so you know.
Thank you, Judge. With regard to the homestead issues, there was no ability for either party to be the prevailing party and get an award of attorney's fees. No statute, no contractual provision. And so although the order of referral required the arbitrator to decide issues of fees, should there be an award or a request made, which the appellants did in their briefs to the arbitrator, he was supposed to award those. Now, there is a statute in the
You're out of time.
for the will contest. Thank you, Judge.
You both did an excellent job today. Your briefs were good. Your spirited arguments were very helpful, and they will help us in deciding this case. Thank you very much. Have a good day.
Thank
as
you.
well.